Welcome to The Workplace, a podcast by CalChamber. I'm Matthew Roberts, Associate General Counsel for Labor and Employment with the California Chamber of Commerce. Hello, listeners. We find ourselves in exciting times to be an employment law attorney. As you are probably aware by now, historic changes to California's Private Attorneys General Act, or PAGA, were approved by the legislature last week and signed into law by Governor Newsom on July 1st. We've talked a lot about PAGA here on the podcast, including recently in a special video edition with CalChamber's president and CEO, Jennifer Barrera, that everyone really should check out in addition to this episode. Today, I want to focus on what's next now that the deal is signed and delivered to the public, including what employers should know and do now that things have changed dramatically in the PAGA landscape. To work through the deal as well as steps employers need to take today, we welcome back two guests to the show. First, Ashley Hoffman, CalChamber's Employment Law Policy Advocate, returns. Thanks for being here, Ashley.
Thanks for having me, as always.
Second, we say hello to CalChamber's General Counsel for Labor and Employment, Bianca Saad. Thanks for joining me today, Bianca.
Thanks for having me, Matt. Very excited to be here.
Yeah, I'm excited to have both of you on here. So, Ashley, with you first, obviously over the past 20 years of PAGA's existence, it had kind of devolved into little more than a litigation-first vehicle for plaintiffs' attorneys to recover attorney's fees while providing very little recovery to employees, while also heavily damaging many small businesses, nonprofits, and community agencies that serve the most vulnerable in California. It was clear the law needed reform, and, well, here we are, Ashley. You testified at the legislature last week that the PAGA changes that we're getting now represent historic reforms that address employers' concerns. First, what are some of the biggest wins for employers in this reform that we got?
So this is really exciting, as you mentioned, Matthew, something we've been working on here at the Chamber for a long time, and then just personally as a former attorney myself. So really, one of the biggest changes is substantial reductions in maximum penalties. So we have implemented into PAGA penalty caps in certain scenarios. So the absolute maximum exposure could be as little as 15 or 30% of the penalty sought, depending on the steps that the employer has taken either prior to receiving the PAGA notice or immediately after receiving the PAGA notice. There is a much more robust right to cure. As employers who've been hit with PAGA lawsuits know, almost nothing under the current law was curable. So even if you had a scenario where maybe you messed up on a regular rate calculation, only owed a few dollars, you couldn't even cure it, and the same penalties still applied. So that, along with some other items, will now be curable. And there are specific mechanisms, depending if you are a larger or smaller business, that you can take advantage of. There's also changes in standing. Recent court opinions had made standing so broad that the worker simply had to allege that they experienced one violation, and then they could sue on behalf of every other worker in California for any other violation under the labor code, which led to a lot of abuse that we saw, I think, in these lawsuits. There was also no limitation on the time that you had to bring the case. Basically, once you were aggrieved, you were always aggrieved. And so we have limited standing to say that the plaintiff must have personally experienced the alleged violations, and they must file their case within the 1-year time period. And then finally, we also do have a narrow exception there for nonprofits that have been doing this for a number of years that represent, certain, especially like low wage, potentially undocumented workers as well.
Excellent. Well, now, Bianca, Ashley highlighted a mechanism that allows employers to take reasonable steps to limit exposure, that 15 or 30% of the penalties as they are in the statute. I think this is a really important part of this presentation or this episode today to talk about what are these steps in the law that employers should know now.
Yeah, great question. So when we're talking about that potential for significant reduction in penalties, we're looking at employers who have taken all reasonable steps to be in compliance. So what does this actually mean? All reasonable steps can include a number of things. So first, there's conducting payroll audits and then acting on those audits based on the results of the audit. So for example, we know that PAGA actions can be based on a whole host of labor code violations, some of which are more common things like unpaid overtime, meal and rest break violations, or expense reimbursements, just to name a few. So if you're an employer and you go through your audit, you realize you don't have a practice in place to ensure that employees are getting, for example, their timely meal period, or maybe you even find late meal periods without, premiums being paid. These are things that you would want to take action on and address immediately. Next, employers should also have lawful written policies related to their wage and hour practices and make sure those policies are distributed and enforced. Also, of course, being aware of your industry specific applicable wage order and making sure your policies are in line with those wage orders. Then there's this really important component on training. So when we're talking about training, this isn't something that is just, required for our HR professionals in the organization. We're actually talking about training that's focused on supervisors and managers, and that they're trained up on the applicable labor code requirements and basic wage and hour rules. So again, looking at things like overtime, making sure our employees aren't working off the clock, meal and rest breaks, again, just to name a couple. And then finally, there's a corrective action component with regard to your supervisors and other personnel who may be involved with wage and hour violations. So again, as an example, in the meal and rest break context, if we know this is an area that's highly technical, ripe for errors because of how technical it is. If you have those clearly drafted policies, but you have employers who are, let's say, lenient about the timing of when they're taking their meal and rest periods, that's obviously a problem, and you want to make sure you're addressing it with that supervisor through things like coaching, providing additional training. It can even be resulting in disciplinary action if it's repeated. I mean, these are just some examples of things that you'd want to do. And of course, documenting your efforts around all of that as well.
Now, Bianca, what I find most interesting about these reasonable steps, as we've called them, is that either way you can mitigate your penalties, whether it's before you get a PAGA notice or even after, right, Bianca?
Yes, that is true. So with the potential, again, the penalty caps, we can also reduce those after having received either a records request or a notice, a PAGA notice, and we can still audit. We can, audit what are the violations alleged. What are our practices around that? Take those corrective actions, make sure we're hitting it in the policies. And then all of this, basically, it's the reasonable steps for prospective compliance can still bring your liability down, potentially.
So in other words, everybody, it's never too late now under PAGA to take the steps you need to help mitigate and reduce your potential liability here. So Ashley, something we haven't quite hit on yet, of course, is when all these changes will take place. Related to this, there was a very interesting development as soon as the deal was announced a couple weeks ago, but before it was actually enacted this week, that a flood of PAGA actions were filed. So what does this tell us about what the previous PAGA was allowing for plaintiffs' attorneys and the new PAGA, and what happens to those claims that were, filed in this flood of actions that we got just after the deal was announced?
Yeah, so under, the prior structure of PAGA, right, all of these penalties, applied regardless of the severity of the harm. And so it allowed plaintiffs' counsels to just walk in and demand, tens of millions of dollars potentially, right, for these violations. And, the courts, of course, have discretion to not award the full penalty. And we saw a lot of cases where courts realized, these penalties are extreme and have gone lower. So now we have these, penalty caps. And again, the court still has discretion, of course, to go lower. And we think oftentimes they should. But, I think in recognition, right, that those plaintiffs' attorneys were going to potentially lose this ability to walk in the room and just demand, $20 million out the gate. We saw hundreds of PAGA notices filed within the first couple of days. I think the day after the deal was announced, it was over 100, when normally we see about 25 to 40. That Friday, over 200. I think it was 227, something along those lines, a couple hundred again over the weekend. But we thought about this. And so when we put in the effective date to be under the new structure, it applied anything filed on or after June 19th. And so for those people who started filing hundreds of notices on June 19th, June 20, June 21, all of those cases will fall under the new rules. And there were a couple law firms actually in particular that were the most egregious when it came to this.
Yeah, talk about proving our point about what old PAGA used to be, right, Ashley, in terms of just a mechanism for plaintiffs' attorneys to get in there and get the fees that they want, as you announced, right?
Yes, exactly.
So, Bianca, now that we know that these changes are now in effect since June 19th, what are the action steps for employers and what resources might they see from agencies and organizations such as us here at CalChamber?
Excellent question. So, of course, there's a lot that employers and businesses can be doing right out the gate to protect themselves. So, as we touched upon, even if you're an employer who's recently received a PAGA notice, right, since June 19th, all is not lost. We know that there are still those reasonable steps that can be taken for prospective compliance that will help with that reduction of penalties. Even if you're, PAGA notice free, of course, those reasonable steps that we talked about with, the lawful policies, conducting the audit, training your supervisors, taking corrective action, all of these things you can start working on now just to really better protect yourself in the event of a claim down the road, which of course our goal is to hopefully prevent altogether. But so to that end, to the extent that employers are looking at, how can we be proactive about this? How can we take these reasonable steps to be in compliance with, wage and hour rules and the labor code and the like? CalChamber will be putting together a whole host of resources. Out the gate, we're going to have later this month a total of 3 different webinars that are going to be touching on all things wage and hour, also specifically as it relates to PAGA. And then we'll also be having a whole suite of other resources, right, to help with this end. Policies, forms, you name it, we're going to be putting something together. So people should definitely stay tuned and be on the lookout for more to come on that end.
That sounds awesome, Bianca. Ashley, anything else our employer and business community should know about PAGA before we close out for today?
Yeah, I think I'll just say, when we were looking at this, a lot of what we talked about today are best practices that we and others have been, emphasizing the importance of doing for a long time. And so we wanted to ensure that those employers that are really trying their best, to comply are not being penalized right under PAGA, especially in the way they once were. And so just really looking forward to, I think, helping out all of our members to make sure that they are doing these audits, doing these trainings, and so they have the best experience possible for the employer and the employee.
Well, Ashley and Bianca, thank you for helping put clarity on a very hot topic and giving our listeners a bunch of action items to begin immediately. And thank you each for spending some of your day here with me today.
Thanks, Matt.
Thanks, Matt. Always a pleasure.
And thank you, listeners, for joining this discussion on the workplace. Please share this episode and subscribe to future episodes of CalChamber's podcast by visiting calchamber.com.